All right, my name's Anthony Bainey. I'm here with Michael Kuzma. He's obviously a local attorney and activist, ran for state senate, ran for a city court judge. And how you feeling today, Mike?
Pretty good. And I was a delegate for Dennis Kucinich when he ran for president. As you know, New York has that weird system for presidential campaigns. You have to run delegates, and I forget a certain number of congressional districts. So I was part of a slate here in Buffalo. Dennis is one of the few decent representatives I've met at any level. He's really a great guy. We used to go to Cleveland to help him on his congressional campaigns.
He was definitely anti-war. I
Oh,
definitely
without
can.
a doubt. Yes, he sued Bush too after his that fiasco in the Middle East.
All right, so we'll get down to the meat and bones. What happened this Tuesday, October 14th, with the Second Circuit out in New York City?
Well, for those who may watch this video, for years they're dear friends of mine, but the owners of Burning Books on Connecticut Street here in the city of Buffalo were targeted by the FBI and other federal agencies in 2012. And they were subjected to physical surveillance, um, mail covers, and so on. And there were two local women, Amy Upham and Selena Lloyd, who were FBI informants. They were living in a apartment above the bookstore. So this case got a lot of media coverage. If you go to the Burning Books website or just do a Google search regarding Leslie Pickering, who's the other co-owner, and Nate Buckley, there were more stories on Leslie. It'll just highlight some of the things that happened as a result of this domestic terrorism probe that was based largely on the information provided by these two women. One of the women had some issues, and what we did is when we learned of this ill-conceived probe, we filed Freedom of Information Act requests,
And
and
when
at
was
the
this first known that this investigation was beginning or was being conducted?
we learned about it in 2012. What happened was a mail carrier inadvertently he was filling in for the regular mail carrier, and there was a something at the post office that there was a handwritten note, and this carrier wasn't sure what that was, but he inadvertently delivered it to Leslie, and I knew immediately that Leslie was or being subjected to a mail cover. They were copying all of his incoming mail before it was delivered. So this substitute carrier delivered the note along with the mail to Leslie, and then that started us on this long journey where we made requests to the FBI, U.S. Postal Service, Homeland Security, and so on.
And what is a Freedom of Information request, or what is the FOIL laws for those who may not necessarily understand just the basics?
Yeah, well, FOIA is a federal statute. FOIL is a state statute, but FOIA was passed during the Johnson administration. It was strengthened in the early 70s, weakened under Reagan, but it allows anyone in America, you don't have to be a U.S. citizen, to request records concerning yourself or an issue of public concern. So we made the requests to these various agencies, and you have there's an administrative process which involves the initial request. There's the agency, upon receipt of the request, is supposed to provide the sought after material within 20 working days. I can tell you that rarely, if ever, happens, especially with agencies like the FBI and DHS. So then, if your request is either ignored or not, or you don't get the requested records. Maybe a lot of times an agency will just send an acknowledgement letter advising you that your request has been assigned a number that, and it was, going to be processed. They don't tell you it may take years, or in Leslie's case, over a decade to process the material. So we filed a request. We got the runaround we'll focus primarily on the FBI, but we got the runaround from the FBI. We filed an administrative appeal, and we ultimately brought a lawsuit in the United States District Court for the Western District of New York. And with FOIA, you can sue where the requester resides, where they have a business, or you could file suit where the records are located. So with the FBI, you could sue in Winchester, Virginia, and then anyone could sue in the District of Columbia. So we brought this lawsuit in the Western District of New York. We brought one for Leslie back in 2014. We brought one on behalf of Nate Buckley in 2019. The Buckley case, we were seeking records regarding his file was much smaller than Leslie Pickering's, but we we filed suit, and then we were challenging some of the exemptions. The government was withholding information regarding those two informants, Upham and Lloyd, and we challenged the basis for them withholding that material. In addition, they withheld information regarding just the names of FBI squads and units. They claim that if they revealed the names of these squads or units, it would reveal there's an exemption under B7 for investigative techniques. And we argued that a name of a squad or a unit could hardly be considered an investigative technique.
Now, what is the difference between a squad and a unit? And then also, just to backtrack just a little bit,
Yes.
um, is there filing fees for the FOIL with the FBI? And also, when you appeal within the administration of the FBI, is there fees associated with that? And obviously, there's court filing fees once you get to the Western District
Yes.
level.
So that there's no fees for making the request or the appeal. There are fees for copying costs. And what the FBI does is they put the stuff on a CD and they charge you $15 for each one. I can remember in the old days when I was helping Leonard Peltier, who was wrongly incarcerated for over half a century, we had the FedEx truck come to my office and we helped them unload multiple boxes of paper copies. So those days are gone. But in Nate's case, there were like 50 some odd pages. So copying fees, I believe the threshold is 100 pages. So anything under 100, you don't pay. So there's no cost to file the request, no cost to file the appeal. And then there's filing fees in the federal court, which become quite steep. In the old days, when I filed pro se cases long before I became an attorney or had actually attended college, the filing fee was $60 back then. Now it's, I think, is it 400? Appeals are 505. So if you're of modest income, even that's quite a hit.
Yeah, absolutely. And then, so the circuit court, because the federal Western District Court had denied basically the attorney fees, and also the Second Circuit affirmed that, saying that it didn't fall under the exemption that you and Nate Buckley, you as the representative for Nate Buckley, were saying allowed for the attorney's fees to be compensated, essentially.
There were three issues. Like, here's the brief we filed. There was also a reply brief, and then even though all of this stuff is done electronically, you still have to file a record on appeal in paper form. And they could easily the courts have something called uh, Pacer, which is accessible. Any member of the public can look at it, and everything has to be in a PDF format so that Second Circuit could easily look at all of these documents electronically, but and this is a very expensive process. There's services that do this on a regular basis. So the filing fees are the least of your worries. And if you're a one person band, you don't have a staff to prepare all this. But there were three issues on appeal. Did the district court, I could even, you have to present questions for review for those listening who want to bring their own FOIA lawsuit. So the first question was, did the FBI improperly withhold information withheld under exemptions B7D, which is the informant or confidential source exemption, and B7E, which is the investigative techniques exemption, and any other question we presented for the Second Circuit is an award of attorney fees and litigation costs appropriate in this case. So we were arguing that number one, this investigation of Buckley and Pickering was illegal and unauthorized. It wasn't actually a law enforcement investigation. They were targeted because of their political beliefs. So, in order to withhold something under the B7 exemption, which is the law enforcement exemption, the agency has to demonstrate that these records were compiled in the course of a legitimate law enforcement investigation. And our contention was investigating two co-owners of a bookstore based on the word of two confidential sources, Upham and Lloyd, hardly could be considered to be an informant. I mean, uh, a legitimate law enforcement investigation. And so we argued that because they have to first, meet that test. And then the other argument we had is that Upham and it was Amy Upham talked to a reporter. So their identities were very well known in the area. I believe was it, yeah, I'm dating myself, but Art Voice did a story and published the names of these two women, and the Buffalo News did a story where uh, the I think it was Upham talked to the one reporter who was working with Phil Fairbanks. So their identities were known. So we indicated too that you had this investigation that was illegal and unauthorized. It wasn't a legitimate law enforcement investigation. And secondly, the identities of these two informants had already been publicly revealed. So in spite of that, the Second Circuit handed us our head and said, "Well, the district court was right when Judge Fascio decided to withhold the information and identities of Amy Upham and Selena Lloyd." Now, with respect to the investigative techniques, based on case law and the plain language of the statute, I argued simply that there's no way you could say that the name of a squad or a unit could be considered to be an investigative technique, and the court rejected that and said, "Oh no, under our precedent here in the Second Circuit, um, they can withhold those names, even though a lot of these FBI squads, and I'll be honest, I don't know what the difference is between a squad and a unit and what have you. And a lot of these squads are listed or they're publicly available if you do a Google search or go to the FBI website. So the Second Circuit, I might add, these are all so-called liberal appointees. You know, you had a Clinton appointee, and you had an Obama appointee, and then you had brain dead Biden appointee. So the shit libs, as Cindy Sheehan calls them, are terrible. I found going to the Second Circuit, they're as bad, if not worse, than like Bush appointees, Bush 1 and 2, and so on.